Hello, welcome to COPS, Tribal Meth webinar series. Today's topic is building effective partnerships with United States attorneys, the Arizona example. Before we begin, I need to let you know that this webinar service includes a feature that allows audio documents and other materials exchanged or viewed during the session to be recorded. By joining the session, you automatically consent to such recordings. If you do not consent to the recording, please disconnect from the webinar at this time. During the webinar today, questions can be asked throughout the presentation using the webinar-based Q&A system on your screen. Simply type the question during the presentation. You may also ask questions over the phone after presenters have finished. Today's webinar, I would like to introduce John Tuchi. John will discuss how the U.S. Attorney's Office of the District of Arizona has successfully worked with tribes in their respective district to implement the Tribal Law and Order Act. John is the Senior Litigation Counsel for the United States Attorney's Office in Arizona, where he is responsible for development of policy and procedure for its criminal division and the training of its 170 attorneys. He is also the district's tribal liaison to the 22 federally recognized tribal governments in the Arizona district. John previously served as a prosecutor in the Office of Narcotics and White Collar sections, as Phoenix Appellate Chief, as Criminal Chief, and as United States Attorney for the period between confirmed presidential appointees. With that, I would like to turn the webinar over to John.
What I'm going to talk to you about today has a lot to do with the ability of your government and your agency to pick up the phone when you have a matter of interest or you need information that deals with federal prosecution or federal criminal investigation, so that you can pick up the phone and get somebody on the other end that you know, that you trust, and can assign a value judgment to get your answer and have a frank discussion. As Eric explained, I'm going to take the next 15 minutes to talk about how our particular relationships have been developed with tribal leadership in Arizona, using the Tribal Law and Order Act more or less as a template. And I would say that I will answer questions as they come up. I'll ask Eric to interrupt me at any appropriate point when you have a question, because I can't see them the way this as the questions come in, the way that this webinar is set up today. But I'm happy to answer them when they come up. That probably makes them more relevant. But over the next 10 or 15 minutes, we'll just walk through how the Tribal Law and Order Act has acted as a framework for improving these relationships and communications, and it's something that can be replicated, I think, in any district in the United States where tribal governments have to interact with the Department of Justice. I think it's important to understand at the outset that the Tribal Law and Order Act is really not an independent new statute or law. What it was, when enacted in July of 2010, is a collection of amendments to existing laws. In other words, it changed the way existing federal laws defined the relationship of the federal government to the tribes and the obligations that the government had to the tribes in terms of what law enforcement would do to improve public safety and how it would do it. So a couple of fairly important points that make sense, that fit in with what we're talking about today. One of the things the Tribal Law and Order Act did was it amended the Indian Civil Rights Act to allow tribes for the first time to prosecute for felonies, crimes punishable by more than a year, under tribal law. Until then, the Indian Civil Rights Act had limited tribal governments to 1 year or misdemeanor jurisdiction. In exchange for getting that enhanced authority, and it's limited felonies, it's the tribe gets to define what they want to make a felony and what they want to assign a greater punishment, but it's limited to 3 years per count, and then you can stack up to 3 of those on top of each other for a maximum of 9 years in tribal custody. But there's a quid pro quo for that. What it required tribes to do was to change their systems to improve the due process and the constitutional protections that the tribal defendants would receive. The two big ways that the changes were made were it required that tribes afford legal counsel, legal representation of anybody charged with one of those felonies, and the legal representation had to be of the same quality as somebody would get in federal or state court under the guarantees of the Sixth Amendment. The second change it made was it said not just any tribal judge can preside over a matter like this, only a tribal judge that has, quote unquote, sufficient training and experience to handle a felony matter could preside over those. And what that sufficient training and experience is somewhat open to interpretation. And we won't know ultimately what that means until someone is prosecuted under this new system and it gets run up through habeas review to the federal court system. And so the way that this particular change in the law has improved our relationships with tribes is it's given us an opportunity to consult with them, to act as an expert, to help interpret this new requirement, and when they want to change their laws, help them suggest and think about ways to do it that are going to be compliant. And we've offered very, very conservative answers to those questions, which is do the absolute maximum so that if anybody wants to challenge the requirement, you definitely have made it. Hire judges and lawyers in these programs that are admitted to a state bar, because that's the maximum qualification that you can get. Really, the answers that we give and whether or not the tribal governments decide to follow that are kind of beside the point. For us, the key is that it's opened the door for greater communication and for the tribes to feel comfortable asking for our help, and then us giving them the experience that whatever they asked for, we delivered. Another area that the Tribal Law and Order Act changed existing law is that it required for the first time U.S. attorneys' offices, when they decline a case in Indian country, to let the tribal community know through the tribal prosecutor and the police chief, one, that we have declined the case, exactly when we declined it, and two, in detail, why we've declined it. We now have a rule as a result of this law in the District of Arizona, and I think most U.S. attorneys' offices do, that there are no verbal declinations of a case. If you are going to turn a case down in Indian country, the declination and the reasons for it have to be in writing. And that writing just doesn't go to the case agent. It also goes to the affected tribe's police chief, and it also goes to the affected tribe's chief prosecutor. And that letter has to have detailed reasons for the declination. In Arizona, we have a very limited number of reasons that are okay. Those reasons all have to do with there isn't jurisdiction for this case. In other words, after looking at what happened, no cognizable federal crime has been committed, or there's a problem with the evidence. We don't think it's strong enough based on what we have to get a conviction beyond a reasonable doubt in federal court. We don't use any, and we don't permit any other reasons. In the past, you would see declinations that would say, well, they're being prosecuted in another jurisdiction, tribally. That is beside the point for us. We will take a case in Indian country if it's a felony, unless there's no offense under the limited jurisdiction we have or the evidence is weak. Why do we do that? Why do we send the letter? Well, there are a couple of reasons. One of them is we don't want tribal courts, tribal prosecutors to have to wait and wait and wait for a federal prosecution decision in case that affects what they're going to do. Number two, we want them to understand what problems we had under our statutes and the evidentiary burden, so that if they have a similar problem, for example, if the elements of their offense are similar under the tribal code to what they are in the federal code, they may have the same issues, and they may want to think twice about charging the case. If the elements are different, or if the evidentiary burden is different, then that's not going to be a problem, and they can study that and take that into account. Finally, one of the things that our letters always has to do is to offer to discuss the case personally with the chief prosecutor and to make all evidence that we have available, so that the tribal prosecutor is not off on her own or his own having to gather things. We give them what we have if they want it, and we encourage the FBI or the BIA to give what they have in their custody as well, so that the tribal prosecutors got the best shot at making a case if we can't do it. The last benefit, though, is probably the most significant, and it's like what we spoke about just a minute ago with enhanced sentencing under the Tribal Law and Order Act. This offers an opportunity for us to communicate on a regular basis about matters of importance where we weren't communicating before, to demonstrate availability, and responsiveness, and to start building up that relationship the way we have. The last two things that I want to talk to you about with regard to the Tribal Law and Order Act as sort of a template for improving the relationship between the tribal governments and the U.S. Attorney's Office is training of tribal police officers and the Special Assistant United States Attorney Program for tribal prosecutors. With regard to training, many of you live in jurisdictions where tribal officers are able to get a federal commission through the BIA's Special Law Enforcement Commission. That is, that when you get that commission, you have been delegated as federal agents through BIA authority to do all of the cases that an FBI agent or a BIA agent could do in Indian country. The violent crimes, federal drug trafficking, federal firearms as well, and some other things, but principally focused on the violent crimes, sex crimes. The U.S. Attorney's Office in Arizona has for the last many years done the training to qualify tribal officers to get that federal agent status. But that's not all the training we do. Again, as encouraged by the Tribal Law and Order Act, the policy we have in Arizona is that if a tribal police chief asks us for training on any subject related to law enforcement, we will provide it, and we will provide it within 2 months, and we will provide it on site. So we will go to San Carlos Apache Tribe, we'll go to Navajo, we will go to Pasquayaki. We don't make anybody come to us. That's not what the Tribal Law and Order Act is trying to indicate. It is trying to indicate working on a government-to-government basis and showing respect wherever we can. And that doesn't mean demanding that everybody comes to the U.S. Attorney's Office. So we go to the tribal police headquarters or to the casino or wherever they would like us to come to do the training. And that can be substantive federal law. What are the elements of homicide or sex assault in the federal system? It can be evidence gathering, establishing chains of custody, demonstrating what the requirement is, the evidentiary requirement is in federal court. It can be procedure. It can be report writing. It can be testifying in court. Any of those things. I just got back actually yesterday from the Fort McDowell Yavapai Nation where I did 8 hours on search and seizure and custodial interrogation and what is and is not permitted under the Constitution and what will and will not be suppressed when we go forward. That's a pretty good example. And then lastly, tribal SAUSs, Special Assistant U.S. Attorneys. Tribal Law and Order Act dictated that U.S. Attorneys' offices are encouraged, again, to open those lines of communication by bringing in, where they want to, where the tribes want to, tribal prosecutors to act as Special Assistant U.S. Attorneys. In other words, it's like being a tribal police officer that's commissioned to do federal cases. The difference here is these folks are going to come in and prosecute cases in federal court with us that come out of their tribal communities. In the District of Arizona, we grabbed that one by the horns, and we have the largest and most comprehensively developed tribal SAUSA program. At the moment, of the 22 tribes in Arizona, there are 13 tribes that have prosecutors who could qualify for the program. That is, people that are admitted to a state bar and therefore can appear in federal court, because that's a requirement of the job. Of those 13, 10 of the tribes so far have put at least one of their prosecutors into our project. We have a total of 16 tribal prosecutors as SAUSs. When those folks come into the program, after their tribes sign an agreement with the U.S. Attorney's Office, we put them through the same background check that our prosecutors and agents go through, and after that, they come to our office for a week of training on substantive law, on procedure, on the expectations of the court, on policies in our office, and on our ethical obligations. And then they shadow our lawyers to grand jury, to the magistrate court, to the district court, They see every hearing that we do in the life cycle of a criminal trial, from initial appearance to preliminary hearings to detention hearings to suppression hearings to pieces of trials and sentencings, change of plea hearings, all of that. If they see enough, our philosophy during that week is watch one, learn one, do one. And by the time they're gone, some of them have actually stood up and represented the United States for that hearing. Once they're done, they go back to their offices, and we then start assigning them cases that come off of those reservations that the tribe has indicated an interest in. So, for example, one tribe will say, we want our SAUSA to work on violence against women. So we're looking for domestic violence cases and sex assault cases where they can be co-chair. We never leave them alone. They're always with another AUSA so that they can learn and don't have sort of the panicked feeling of being left alone to sink or swim. And they do the kinds of cases that the tribe wants them to do, and they do as many as they want to. We're not trying to overload anybody or push our work off on anybody. We want the experience to be what they want. And again, the principal value of that is not that more cases get done. They don't, because the same AUSA who's doing them as co-counsel would be doing them by themselves without the SAUSA. The principal advantage is they learn a lot about what it takes to develop, charge, and take to trial a federal case, given the high evidentiary requirements and the high expectations of the federal court. We learn about the tribal parallel process. And secondly, the relationships develop, the familiarity develops, and the respect develops, so that when there's an issue, that tribal prosecutor from their home office can pick up the phone, call their AUSA buddy or co-counsel, and say, hey, I need this information, or what's going on here, or I think this is wrong. And we've got a level of communication that didn't exist before. Eric, I'm going to stop with sort of the bulk of the presentation now, and if there are questions, I can go into those. If there are questions that have come in from the participants, or if you've got questions lined up, I'm happy to answer those.
Yes, John, we have a few questions that have come in. Speaking with we had a question about the tribal prosecutors. How is this relationship with the tribal prosecutors enhanced prosecution of crimes within your district?
Well, as I said before, it's not that adding a tribal prosecutor as a SAUSA, Special Assistant U.S. Attorney, means that we're doing more cases, because in Arizona, we have a rule that those cases get done no matter what. We never decline a case for resource reasons. Remember, I had said to you earlier, we decline them only if the evidence isn't there or if there's no crime there. But if there's an issue with resources, we find a way. Somebody who's not ordinarily doing the Indian country cases will do them. They'll always get done. So adding the SAUSAs doesn't add to our capacity to do more cases. But what it does is it puts in our office or in communication with our office somebody who understands the tribal community and its particular needs and the impact of having this offender out in the community versus not in much more focus for us. So we use the tribal prosecutors as sort of a bellwether for what's important to the community, what impact will this particular case have on a community if we do it one way versus another, if we charge it one way versus another. And secondly, it gives us somebody in the community so that if there are issues with how the evidence was gathered or if there is something missing, that tribal prosecutor is right there. Sometimes, right across the parking lot or right down the hall from the tribal police, and recognize most of our cases are investigated by tribal police. As between having, for example, in Arizona, 5 or 8 FBI agents to cover all of Indian country, and on the one hand, and on the other hand, having, say, 300 uniformed Navajo Department of Public Safety officers on Navajo to handle those cases, or 42 White Mountain Apache police officers in that community. We are heavily relying on those tribal police officers that have gotten their SLEC, their federal commission, to do the vast majority of the investigation, if not all of it. And they have relationships with that tribal prosecutor. So if something needs to be done and it needs to be done quickly to save a case, that tribal prosecutor, who is also the Special Assistant U.S. Attorney assigned to that case, is right there on top of it and can get those things moving. It is, I can tell you, it is a beautiful thing in terms of the speed with which we can get things done. And we've got examples that I can list to you about that enhanced communication and how it makes things, fixes cases, saves cases, and does it really, really quickly. That's just one way that it's enhanced it. The second one is when somebody becomes a tribal Sauza, they are treated just like any of the other AUSAs in our violent crime unit, in that they have a voice at every one of our staffing meetings about whether or not a case is good enough to do, about whether or not the evidence is strong enough. And they are there to advocate for those cases, just like anybody else. And they are there to poke holes in those cases as we're evaluating and deciding whether or not we have enough to charge, just like anybody else. And it is really nice to have that input, valuable to have that input. I think for us, because it's another perspective, and I think for the tribe, because it means they actually have a voice in the charging decision. What else you got for me, Eric?
Okay, thanks, John. We have a few other questions. One dealing with the enhanced penalties that the Tribal Honor Act gives, and how does the tribe first start developing new criminal codes to match these enhanced criminal charges they have?
It's a great question for somebody that's obviously seriously thinking about how this would work. The tribe is free to decide whatever it wants to make a felony. So, for example, you could look through an existing tribal criminal code right now and say there are 186 offenses and they're all misdemeanors. They're all punishable by a year or less. If a tribe wanted to, it could turn every single one of those into a felony, arguably. No one's going to do that, obviously, because with that felony, comes a lot of tribal jail resource questions. And if you're already pressed for space when you have to let people go in less than a year, the last thing you want to do is make everything punishable by 3 years. So most tribes are deciding, picking and choosing what they want to emphasize as a matter of policy are the biggest problems in their community. You will see tribes that are going through and their council is revising and making all the sex assault offenses felonies. Some are making all the drug distribution offenses felonies. Some are making bootlegging a felony. Some are picking some of each of those things that we talked about and making them felonies and leaving others misdemeanors. And then, also now they have a homicide charge that is not just a misdemeanor, so you can do it that way. But the how is an issue of sovereignty. Every tribe is free, as I said, to choose what they want to make a felony. What I will tell you, though, is that in Arizona, we've got several tribes working on this, and in fact, we have one that's done it already. The Hopi tribe is the very first in the United States to have done everything necessary to take advantage of this enhanced felony sentencing, and as of September 28th, they started charging people under the new code with charges that are going to result in these felonies. Tribal punishments of more than a year for each count, and we're going to watch those first few prosecutions work their way through the system and then get challenged in federal court, and we will be there sitting with the Hopi tribe defending their system and standing it up. But where I'm going with that is the other tribes in Arizona that are looking into this and the Hopi tribe have all consulted with our office. Our office has a policy that if you want training on the Tribal Law and Order Act, and if you want us to come and tell you how the law will be interpreted and the way that you can enact these laws so that it will stand up to challenge, we will do it. And I have provided that training to 12 tribes in Arizona, and I have provided that consultation service to 6 tribes in Arizona, including Hopi, and continue to keep going back and going back and going back, and did go back right through the last tribal council meeting where they passed this at their request to testify and give legal advice. That's where I was saying to you earlier, we give conservative advice to make the new system as bulletproof as possible so that when it gets challenged, no court will ever find that it is out of compliance with the requirements of tribal law and order. Your tribal liaison in each of your respective U.S. Attorney's offices should be available for that same purpose. And if they are not advertising their availability and if they have not volunteered yet to come out, you can make the request, and they should do it. And I will also offer you this, regardless of where you are. If you can't get assistance because your U.S. Attorney's Office isn't equipped yet to do that, and you need it, then you should contact me. and I'll do what I can from here.
Awesome.
Eric,
Thank
what's
you, John,
next?
that's a great response and great help. Some of the questions we actually have gotten in is everything is about resources. How can I get resources to have the qualified judges and have qualified prosecutors and public defenders? So what are some actual resources tribes can possibly apply for grants or other various resources to implement parts of the Tribal Law and Order Act that require the higher requirement?
Well, there are a couple of ways it can go. Obviously, this is the question that matters the most to people because resources are tight for everybody. And while they're not plentiful from the federal government, the Department of Justice has a couple of pockets where you can look. The consolidated grant-making system, which includes COPS grants and grants from the Office of Victims of Crime and others, have some money. Another good pocket for this right now is the Bureau of Indian Affairs Office of Justice Services. They have stood up a separate unit in this administration that deals with improving tribal courts. And that entity has the ability to make grants on a one-time basis or I believe also on continuing funding basis. Not a huge amount of money, but some, which I've already seen in the District of Arizona. Why? Because we aggressively encourage our tribal chief judges and others to seek these things out. And so, for example, in Arizona, on the Hopi tribe, as part of this upgrading of their system to a felony system, the chief judge made a request for, I think it was 30 or 60 ankle bracelets for remote monitoring of people who are on release. And the theory behind it was if you put people who are not physically dangerous back in the community on pretrial release or on supervised release, you free up jail space. And you can still make sure that they're complying with the conditions of their release, i.e., that they're where they're supposed to be, just using the ankle monitoring. That means that you've got jail space for the more dangerous people that need to be incarcerated. That's one smaller flavor. But I can also tell you that they are going after, other tribes are going after grants to fund a part-time public defender who is state bar admitted somewhere. They are recognizing, and I think this is important to know, when a tribe looks at doing this and saying, well, I'm going to take advantage of enhanced sentencing under Tribal Law and Order Act, now I've got to have a public defender where we didn't before. The tribe is going to be paying for the defense. And the first thought is, wow, we've got to hire somebody full-time. And in some tribes, that may be the case. If the volume of possible felonies is high enough, you may have enough to keep somebody busy full-time. But in most tribes, that's not the case. In most tribes, you might have one of these possible felonies coming up 1-2 times a month. That's actually been Hopi's experience over these last 2 months since they've been charging it. It's only in 2 months they've got 3 of these felonies, and so they realize they don't need somebody full-time. What they need is enough money to contract with a lawyer who's practicing somewhere else on an hourly basis or something like that to come in. And that is a much more manageable amount of money that can be absorbed in one of these grants that I'm talking about from BIA or from Department of Justice. Another way to do it also is to have part-time judges, because again, you're not going to need a judge that is felony qualified to be full-time. They only need to show up to do these matters. And so, for example, Pasquayaki right now has all state bar admitted judges, but other tribes in Arizona do not, and what they're thinking about is hiring a judge on a contract basis for just those things. That is another item that would be a target of a very well-defined and limited grant request. The last thing I would throw out on that is your United States Attorney's Office tribal liaison ought to be able to help you with identifying these grant opportunities and with formulating your grant request. As an example, and I'll use Hopi one more time because they're so far along. The Hopi tribe recognized that if they're going to start locking people up for over a year apiece, they're going to need more jail space. And so their tribal council put together a working group on detention, and we have lent them the services of my deputy tribal liaison, Hope McDonald Lone Tree, who is a former tribal council member at Navajo and who worked on a successful grant application to get jail space built on Navajo with federal dollars. She is lending her expertise to the Hopi tribe through her work here at the U.S. Attorney's Office, and they are taking that expertise, and with that they are formulating a top-notch proposal and plan to be submitted to the Department of Justice and other government entities for funding to get a jail built. That's all I got, Eric.
Okay, awesome. Thanks, John. I would like to announce to the participants if there are any more questions, go ahead and ask them either over the phone or on your chat or Q&A box. But I do have a couple more questions that have come in, John. Speaking to the Special Law Enforcement Commission cards for tribal police officers, there's a few questions in from people asking whether or not tribal police officers do have to have an SLAC to charge in U.S. District Court, or if the tribe does not want to go into a relationship with the BIA, do they have to have the SLACs?
Well, that's a decent question, and I will tell you that as a matter of okay, the easy one is if they have the SLEC, then of course they can. The tougher question is if the tribal officer does not have an SLEC. Well, if the tribal officer does not have an SLEC and therefore is not a recognized federal agent, there are a lot of things they can't do to further a federal investigation. For example, they cannot be the affiant on a federal search warrant application or any other request for court process. Under the law, anyone can make an arrest, including a federal arrest. But the issue is, if you don't control who that anyone is, the United States can wind up with a great deal of liability issues. And so the Department of Justice and most individual U.S. attorneys' offices have a policy that unless you are recognized as a federal agent, either directly or through an SLEC, you're not able to effect federal arrests. And in those instances, you need the cooperation and participation of a federal agent from either FBI or BIA or somebody else who's empowered to do it. In Arizona, we have some experience with this model because several of our tribes have been SLEC participants since early in its availability. But Navajo was not. They just started doing it about 2 years ago, and in that space we've trained 270 officers for the SLEC. But before that, their criminal investigators, and sometimes their patrol as well, were involved in federal criminal investigations, and they were pretty much the default key officer or case officer when it came to supporting the AUSAs on the case. But they were unable to make a federal arrest because of this issue. When it came time to do the arrest, to execute the federal arrest warrant, or if there needed to be a PC arrest without a warrant, they always needed to get somebody from FBI or BIA. And if they needed a search warrant, we needed somebody else to be the affiant.
Okay, John, thank you. If you have any more further points, I know there's no other questions from the participants. Do you have anything other to say, John?
No, not unless there are questions. I'm good to go.
Okay. All right. So that completes our time here today. We would like to thank you all who have participated in today's webinar. Please take a minute to fill out our survey. To download previous webinars and handouts from the series, please visit www.methopedia.org/webinars. Thank you.